Ms.Sanduni Wickramasinghe, a highly experienced attorney at law, is specialized in privacy, data protection, internet governance, cybercrime, and human rights in the digital world. Currently working with a telecommunication leader in the private sector, Ms. Wickramasinghe has extensively studied information technology, law, and digital technologies. Her expertise in handling matters is related to right to information, data protection, commercial contracts, and regulatory aspects of mobile finance.
Good afternoon, ladies and gentlemen. First of all, I must thank especially Mr. Janathan Fernando and the Sri Lanka Press Institute for extending this invitation for me today. And before I begin, I should give the usual disclaimer that the views that I'll be expressing in the next 5 to 10 minutes would be solely my personal views and does not reflect the official position of my employer, Mobitel. So, during the course of the next 5 minutes, I will try to roughly go through the concept of the difference between right to privacy, right to information, and the right to personal data protection, and how the complementary aspects of RTI and RTP, like right to privacy, and there are the instances in practical scenarios from a telecom perspective, how they overlap, and a proposal how to balance, issues we overcome when practically implementing the RTI regime in the Sri Lankan context. So basically, RTI we recognize is there as a positive right because it requires the government to proactively engage in practices to ensure that there's access to information, there's transparency, and so on. Whereas information privacy is concerned, it has aspects of both of a negative right as well as a positive right. It requires the government to refrain from infringing your privacy as well as having safeguards in place to ensure that your privacy is not infringed. And when it comes to defining privacy, now that's, I could go on about defining privacy, but is it about secrecy? Is it about having, a right to hide? Or is it about contextual concept? Should privacy be considered in its context? And what about organizational privacy? And then, so privacy it's not a universal value per se, but it's more of it differs from one culture to another. It differs from one organization to other, and what's considered as private to me may not be considered as private to you. So those are the dynamics we need to keep in mind when trying to balance the two rights. And also about the personal data protection regime. It's actually an extension of a privacy regime, and whereas a right to information talks about having access to your information, a personal data protection regime is essentially about having control over the collection, the use, the storage, the dissemination, and retention of your personal information. So there is a slight difference between the two rights. And as I said, so from a Sri Lankan perspective, there are ways where the RTI regime complements the absence of a specific right to privacy or data protection regime. We see that the RTI empowers people to seek information about themselves. So it's one of the principles that comes in with a right to protection regime, like having access to your information, which that right is actually granted by the Right to Information Act in Sri Lanka. So as a person, I could approach a government entity and demand the information that it holds about me. And the difference is that the RTI regime is limited from the fact that it doesn't give the person the right to correct the information if it's wrong, or to have that information deleted if it's obsolete. So these are certain rights that are specifically enumerated through a data protection regime. However, as the case may be, it's always better to have something than nothing. So I always feel that Right to Information Act gives us that power to have certain control over our personal data vis-a-vis government entities. So the potential conflicts that we have come across when responding to right to information requests is one that how do we balance these two rights? In one hand, we are expected to proactively disclose the information, but on the other hand, we are pulled back to a step back to consider if this violates privacy. And it's quite, the section 5.1a criteria is quite straightforward, because it's commendable to see that the RTI recognizes privacy as an exemption. And so one limb of that criteria is that there should not be a relationship, if the information sought has no relationship to a public activity or interest. Now the issue, one practical issue we have come across is that the requester is not required under the Sri Lankan law to disclose the interest or reasons for asking that information. So in the absence of stating a legal interest, we are kind of at a standstill to discern whether the information sought is actually public activity or interest. And second, the second exemption given is about unwarranted invasion of privacy of the data subject. Now, then again, the issue comes up as we need to see this in a holistic view, because the RTI applies to private sector as well, like private sector which performs the public functions under license issued by the government. So these are employees who are primarily in the private sector. So in the absence of a legislative definition of what constitutes privacy, and not having a prescription by the legislature or the regulator saying that these are the limits of privacy and these are the limitations or the extent of privacy, then an information officer is in a difficulty to balance these two rights. So, and the proviso to our section 5.1a is that obtaining written consent of the data subject and the large public interest test. The written consent requirement is pretty straightforward. You are expected to have we don't rely on implied consent. It has to be written consent. But then again, from a practical point of view, sometimes we fall into administrative difficulties in trying to gather this written consent of customers. If I may use an example, if someone requests information of subscribers who has attended a certain meeting in a certain location. So do we write to all those subscribers asking for their permission? We could be talking about hundreds of people. So, and then again, it brings back the other question of whether the subscriber data, say location data, is essentially personal information. So the question about certain metadata being personal information or not has to be clarified not by the information officer, in my opinion, but it has to come from a legislative prescription saying that what constitutes personal information, what does not. So those are the issues that from a practical perspective we have seen. And if I move on to the balancing the two rights. So I have listed out as questions, so it's easier to follow. One right superior to the other. In my opinion, and what I find in international, like if you look at the ICCPR or the ECHR, is that those are considered as equal rights. One does not overpower the other. So in that context, we need to consider, in the absence of a legal regime in Sri Lanka define privacy, how can we actually achieve this task? Like for example, a person having, in a privacy regime, a person has a right to erasure of information that is considered obsolete. But on the other hand, the RTI regime would stipulate that information has to be retained regardless if it's obsolete or not. So I, as an information officer, am I compelled to give that information, or do I stick to the privacy of the individual concerned? Then again, and also there are issues of right to anonymity, which might come anonymity of a person, and how does that reconcile with the right to information of the general public? And it goes on. So just for the interest of time, I'll just skip ahead, and whether sector-wise protection of information privacy is in fact sufficient to balance these competing claims. Lessons from the telecommunications sector, I would say that the Telecommunications Act and the license that is granted to operate a telecommunications system by the TRC stipulate provisions for information security. And we need to identify that information security and information privacy should not be used interchangeably. It's like, if I may use a very basic example, imagine a window, and if think your system is like a window. So to avoid avoid a thief getting into your house, you insert bars. So that's information security. But you cannot prevent, the bars cannot prevent a peeping Tom from just peering through your windows and seeing what's going on inside your house. That's what you put the drapes on. And the drapes, in fact, is the information privacy aspect. So in the telecommunications sector, what we have realized is that it relies solely on self-regulatory aspect as well. And there's lack of guidance coming from the regulator or the legislature clarifying what constitute reasonable processing of data. And as you can see, like Jayanta pointed out, in the e-policy, government e-policy, it speaks about having information processed according to the law and regulations. So when the law is silent, where do we draw the line? So these are the dilemmas which we have, in my personal opinion, that really creates a conundrum between enforcing right to information as well as right to privacy. So with that thought, I would simply leave this with you, saying whether just trying to recognize the two rights as dynamic in its own context, and whether the Sri Lankan legal framework should move ahead and recognize the need for an explicit right to privacy in order to reconcile these seemingly competitive, or rather seemingly collusive rights of right to information and right to privacy. Thank you.